All right, so today I get to do something a little bit special. I don't always get to do this. I get to walk you guys through some attorney communications and my responses to them. Now, normally I deal with attorneys because I'm representing someone else and have to have communications with them about the case, and I can't share those. But this one is me. It involves me. It's directly about me. And so it's a communication I received from Kelly Long's lawyer, Laura Elkind, and my responses to it. Now, this is for educational purposes, but this is not legal advice in any way. This is not your situation. I am not your lawyer, and you should never take legal advice from someone on YouTube. But what you should take away from this is the reality that lawyers and their communications are just communications from people. And oftentimes those lawyers will try to exert some sort of authority because they are a lawyer, and therefore try to intimidate someone who is maybe not a lawyer or who is on the other side of an issue, and pretend that their communication has some actual force or effect of law. It very, very often does not, especially if it comes by email. It's literally just a threat. And so if you treat it that way and you seek counsel, you can appropriately learn how to deal with this. Let me show you my approach in my responses to Laura Elkind, the attorney for Kelly Long. That is the mom of Sophie Long in this I Stand with Sophie Long case that I've been covering recently and has been going on for over a year. A key point in this is that this has been going on for quite some time. All right. Here we go, guys. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit like, subscribe, turn on your notifications. Make sure you don't miss any videos. Why would you ever want to miss these videos? Here we go. So this is the email chain. This is the first email I received from Laura Elkind. We're going to scroll up through them. There are 4 emails total. Her sending me one, me responding, her sending me a second one, and me responding again. We'll read all of them in full, and I'm going to scroll up through them. So, I haven't cut anything out. I haven't clipped it. There's no communications in between them. This is the full thread. Okay, so on August 4th, Laura Elkind sends me an email. It says, "Dear Mr. Rekieta, it has come to my attention that you are saying on your YouTube channel that I have doxed 2 individuals and caused one of them to lose his job. That's not true, but we'll get to it. To be clear, my only involvement with those 2 individuals was to communicate private cease and desist demands directly to them. I had no part in disclosing my communications with these individuals or complaining to a third party regarding their conduct. I have not doxed anyone, nor have I instructed anyone to do so. I am bewildered that as an attorney, you would make such false, unsubstantiated statements on your show." Now, this is in response to a show that I did following the doxing and subsequent firing of a friend of mine, Kiwi Farms Ken Jennings, who's been on this show before. He's an active member of the viewers and all of that stuff. And he wanted to read through Michael Long's petition for a writ of mandamus and some other documents. Laura Elkind sent him a cease and desist, claiming that those documents were under seal. This was not true, and that's a critical aspect of this. Now, I did not accuse Miss Elkind of actually doxing Kiwi Farms Ken Jennings or getting him fired. What I suggested was the timing was very, very convenient between her sending a cease and desist, Ken starting to do his show, and after his show, him being doxxed and then subsequently fired within a period of like 48 hours. And how the access to those records at the time, according to her own claim that the file was under seal, was extremely limited. And that as a person who is a party to the case, she would have access to that limited information. And I found it highly suspicious that all this happened very quickly. Now, that does not mean that she did it. And I said that at the time. I still don't know if she doxed anyone. She says she did not. I'll take her at her word on that. That's good. I'm glad she didn't do it. However, I did find the timing very, very convenient. Now, let's move on to my first response. "Hello, Laura. You probably do not want to broach the subject of bewildering actions from lawyers with me following your absolutely ridiculous, manipulative, and false claims in your cease and desist emails. That said, I have not accused you of doing this because I can't know if you did it or not. I stated on my show that the timing and the circumstances are suspicious, and given your willingness to misrepresent the issues in your cease and desist emails, I found the whole thing to be very convenient. Thanks for letting me know that you did not dox anyone, but frankly, doxing would be the least concern that I have about your behavior in this matter. Your cease and desist letters were atrocious and a disgrace to the profession. Trying to leverage your position as an attorney against lay people, who, by the way, ended up correcting you in real time, which was funny, is behavior unbecoming of an attorney. Misrepresenting facts and law is embarrassing. Peace to you, Nick. So this is my very moderate response to Miss Elkind, who I truly believe royally screwed up in those cease and desist letters. And again, you'd have to go back and watch the show, but she claimed that the appellate file, the petition for writ of mandamus, was under seal. Now, when she did this against another of my viewers, who has his own channel as well, Spectre, she did this to Spectre and said that the file was under seal. Spectre went ahead and called the Fifth Court of Appeals in Dallas to find out if the file was under seal. We played the recorded call on the air. Turns out, of course, it was not, because they never filed any documents to put this under seal. There was no petition to seal, no motion to seal, and they hadn't even at the time filed the trial court's sealing order in the appellate case. So, literally any member of the public at all could go into the court and request a copy of the documents, and they would give it to them without any question other than whatever administrative fee they would have to pay to acquire the documents. She was not correct about this. And as an attorney on the case, managing some aspect of the public side of it, she should have known that what she was saying was not true. At best, her statements were negligent. I happen to think otherwise, but hey, I'm a jerk, so I can do that. Now, let's get up to Laura's response to me, which came a little bit later, August 5th, so the next day. Mr. Rekieta, no. You did insinuate that I doxed these individuals and got one of them fired. Did I insinuate? That's a little stronger than I would say, but okay, I still didn't state it. I did not state it as fact, and I even qualified it with, I don't know if she did this. I can't know. Now you admit that you did not know whether I doxed them or not when you made these statements. And again, I admitted it at the time as well. Now, in Laura's defense, she has probably gotten just a clipped version of what I said that is taken out of its full context, and that is fine. If she's ignorant on the issue, then she's ignorant on the issue. It doesn't really bother me. Again, this is just an angry email from an attorney. It doesn't mean anything. There's no legal weight behind this email. There is nothing to it at all. In any case, she continues, in any case, it is comforting to know that the legal profession has such an expert arbiter as yourself. Why, thank you. I see from your website that you have extensive experience in many areas of the law, so many that you cannot even specify them, which I don't know where she got the extensive part. I don't think that says that anywhere on my quote-unquote website, which is pretty much just a Google landing page for my business, which I think even directs to a couple YouTube videos, but that's fine. There are no misrepresentations in my cease and desist demands. But if you are the kind of person to reveal the most intimate private matters regarding little children, go right ahead. There is a cause of action for that, and it's called invasion of privacy. There's the threat. And I think you said this recently on your show, the internet is forever. Isn't it great that this intimate private information will follow these children around for the rest of their lives? Thank you, Laura Elkind. Now, here's something to remember. Laura Elkind is not Sophie Long's attorney. Laura Elkind is representing that my revealing of private facts or whatever she's claiming about Sophie is in her representative capacity, and that she would be able to bring a tort called invasion of privacy against me. But Sophie Long actually has an amicus attorney representing her at the time. Now, in theory, at some point in the future. Could she represent Sophie Long through one of her custodians? Maybe. Sure. She could presumably represent Kelly once Kelly has full authority to do so. And she may be the legal custodian over these matters. But as Sophie is currently represented by an amicus attorney, and I'm pretty sure that Laura Elkind is not working with her because that would be an issue, then I don't think Laura is actually the right person to bring this cause of action at this time. But the statute of limitations on this is something like 2 years in Texas. Might be 1, but I think it's 2. Doesn't really matter because it's not an invasion of privacy, which we'll discuss. So here we go. Here's my response. And this one's a little long, and I apologize. But, sometimes you have to go ahead and issue a little bit of a longer response. Ms. Elkind, your perception of my statements is one thing. Reality is another, and it isn't my duty to marry the two. Thank you for visiting my website. I appreciate the traffic, but I've never found it effective in my market. The sad part about this is my experience is irrelevant to your actions and your rather unfortunate cease and desist letters. Remember the ones where you insisted that the petition for writ of mandamus was under seal, except it wasn't. The ones where you represented to presumably unrepresented parties that their disclosure of a public document under a fictitious seal from a court who doesn't even have jurisdiction over them was somehow intrusion on privacy or otherwise improper. That's a misrepresentation of fact and law that at best is just negligence. Even were the sealing order from the trial court in effect on the mandamus petition, it wasn't. The sealing order from September 30th that you filed subsequently, after being informed by a person you threatened that it was not in fact under seal, that sealing order cannot bind people who are neither before the court nor under its jurisdiction. As an expert with vast experience, I can only assume that you would know this, which makes me wonder if your misrepresentation was merely negligent or rather more malicious. I appreciate the permission to reveal the most intimate private matters regarding little children, and will assume that, as you are acting in a representative manner, I have your permission and blessing to do so. As you have instructed me to go right ahead, you'll have a hard time making a case that the matters continue to be private. Of course, that's me being snarky, okay? Of course, invasion of privacy in Texas doesn't cover matters of legitimate public concern without a physical or digital intrusion onto the plaintiff's property, neither of which I have done. It would be difficult to argue that there is no legitimate public concern in a case involving a quite public custody dispute that launched with a viral video viewed millions of times and of which the complaining party has hired a public relations firm to manage the public concern. A case which is broadly covered on Facebook, YouTube, TikTok, and other platforms. A case which has official public commentary from government employees. A case with active missing persons reports and coverage in local, national, and international mainstream press. And then I cited her a bunch of examples of these things. Something is always fun to do is just to, cite your sources. But as a lawyer with sufficient experience to flex on journalists from other states, you probably know that. Sorry, ma'am, I don't capitulate to bloviating nonsense just because it comes from a licensed attorney. Peace to you, Nick. Now, that is my response to Laura Elkind. It is appropriately toned. It was rather moderate. I didn't do any of the insulting stuff that I would normally have done just because, look, this is some normie weirdo down in Texas who has no idea how the internet works and is probably used to people capitulating with her cease and desists and with her threatening emails because those people are involved in custody disputes that she is also a part of, or maybe business litigation. But you're in the realm of publicity, lady, and if you're going to send emails and stuff like this, you have to understand that someone who deals with publicity on a daily basis, talking about this stuff, I'm just not going to be scared of your stupid email, ever. Now, let's talk about one more thing. Laura Elkind is also just wrong on the law of whether or not this would be an invasion of privacy. It would not. It is not an invasion of privacy. Invasion of privacy does not apply to matters of public concern, as there is something called the First Amendment. Now, that's a simplified version of the test, but let's read how Texas deals with this, and you guys can make up your own mind, all right? Here we go. The First Amendment mandates. This is from Campbell versus Seabury Press. This is from the Fifth Circuit Court of Appeals, which is the Federal Circuit Court of Appeals that covers the state of Texas. And they're applying Texas law on this because this is a Texas cause of action for invasion of privacy. It just happens to be in federal court. All right. The First Amendment mandates a constitutional privilege applicable to those torts of invasion of privacy that involve publicity. The constitutional privilege clearly applies to the tort charged in this action, the public disclosure of private facts. This broad constitutional privilege recognizes two closely related yet analytically distinct privileges. First is the privilege to publish or broadcast facts, events, and information relating to public figures. That one doesn't really apply in this case, although arguably, and I hate to put it this way, but arguably Sophie Long is a limited purpose public figure. Now, I don't know if the public figure doctrine is super appropriate to apply to a child who this has been basically done to by their guardians, and we don't need to get there anyway, and we don't need to get into what exactly that would mean in other aspects of law, because second is the privilege to publish or broadcast news or other matters of public interest. And again, as I laid out in the email, this is unquestionably a matter of public interest. In fact, both parents have utilized public interest in this case, both of them while being legal custodians of Sophie Long. Michael at the beginning, Kelly later on. Both of them have done this. Both of them have employed the press. Both of them have employed social media. And that's just the reality of the case here. All right. So the inquiry in determining the applicability of the first privilege focuses on the person. We're not really interested in that because, like I said, I don't want to get into whether or not Sophie Long is a public figure. That's a weird sort of scenario, and it carries a lot of implications. And it's not her fault, right? It's not her fault here. But in contrast, the inquiry in determining the applicability of the second privilege focuses on the information disclosed by publication and asks whether truthful information of legitimate concern to the public is publicized in a manner that is not highly offensive to a reasonable person. This latter privilege is not merely limited to the dissemination of news, either in the sense of current events or commentary upon public affairs. Rather, the privilege extends to information concerning interesting phases of human activity and embraces all issues about which information is needed or appropriate so that individuals may cope with the exigencies of their period. The ambit of protection afforded by the second privilege often encompasses information relating to individuals who either have not sought or have attempted to avoid publicity. The privacy of such individuals is protected, however, by requiring that a logical nexus exist between the complaining individual and the matter of legitimate public interest. Okay, so what this is saying, in a nutshell, is that so long as there is some sort of newsworthiness, some sort of public concern going on here, and there's a logical nexus between the private issues and that public concern, there is a First Amendment protection to broadcast these quote-unquote private facts. Because they're not, and this is going further, right? The facts that we have been talking about on this channel weren't private. They were actually public. They're part of a public lawsuit. They were published by the courts. Not only that, a judge in the matter had disseminated the information privately to fans of one side of this thing. He had disseminated them through Facebook in instant messages. And further, we have official statements by police on this. We have news coverage all over of this. And so these private facts, if you can even call them private facts at this point, are matters of legitimate concern in regards to this issue. They are logically related. There is a nexus between them. So, Laura, I'm sorry, but you point yourself on your website as an expert on invasion of privacy, which means you know you're lying in your email about this being an invasion of privacy, because just a cursory review of Texas law would show you to be incorrect on the issue. This is certainly a matter of public concern, and your client probably your law office, the law office of your co-counsel, David Routson, and the PR firm that you guys hired have contributed to the publicity of this issue. But even if you hadn't, Michael Long made the issue public a long time ago. And you guys raised a big stink about it. In fact, you cited the publicity as the reason that the court needed to issue a gag order on the parties. Guess what? I'm not a party to this lawsuit. Would never want to be. Don't like family law that much. Have done enough of it to realize not my favorite thing. Don't like seeing kids in distress like this. So, that being said, Miss Elkind, with respect, fuck you. Peace. Peace.